Michelle, are you online? Great. Well, we will start with the hearing portion of our meeting today. The first matter that we need to address, I need to put on my glasses so I can read it. Docket number 2022-012, cause number 997-01, in the matter of formal rulemaking to amend the oil and gas program rules pertaining to the definition of oil and crude oil for tar sands operations resulting from Senate Bill 146. So we'll turn the time over to you.
All right. Good morning. I'm Natasha Balliff. I'm the Legislative and Policy Coordinator for the division. Today I'm just presenting in front of you, asking for a notice of effective date from the board. So as a little background, this is the presentation I gave back in June on the tar sands rulemaking. Again, it was from Senate Bill 146, oil and gas amendments, and this just clarifies, or it changes the definition of oil and crude oil. And the only difference is it'll go from our minerals program to our oil and gas program if the crude oil is coming out of the wellhead as a liquid instead of a solid. This is the timeline that was presented. So I presented it back on June 22nd. It was published on July 15th in the Utah Bulletin. That opened up the public comment period, and that closed on August 14th. We did not receive any public comments on it. Before we had begun the formal rulemaking process, we did receive a comment from UPA. They were in support of it, and they were encouraging us to go ahead with it. And then today, August 24th, I'm presenting this again and asking for an effective date, and that can be as early as today. As soon as you guys give me a date, if you want it today, tomorrow, Friday, whenever, I can file that with the Office of Administrative Rules. And then finally, this is the language change that happened within our rules. And if you guys have any additional questions, I'd be happy to answer them. If not, I will just wait for a notice of effective date.
Thank you, Natasha. Board members, any questions about the effective date? Do you know of any conflicts if we assign today as the effective date?
Nope, there shouldn't be.
So it sounds like we need to have a motion to adopt the proposed rules. You mentioned there hasn't been any public comment or objections to this, so I think we're okay there. So I guess we need to entertain a motion to adopt the proposed rules. Anyone would like to make that motion?
I'll move to adopt the rules effective today.
Is there a second? Any discussion on the motion? Hearing none, we'll go ahead and vote. All those in favor say aye. Before we do that, is there any need to do a formal vote with Julianne? Okay. I'm sorry, go ahead. All those in favor say aye.
Aye.
Any opposed? Motion carries. It's unanimous. I think you're set to go, Natasha.
Awesome. Thank you so much.
Thank you. The next matter, our docketed item, is docket number 2022-018, cause number 132-05, in the matter of the request for agency action of Uintah USA Inc. for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners. And I will stop there, and we will take appearances of counsel at this time.
Thank you, Mr. Chairman. Fred McDonald of Counsel with Lear & Lear on behalf of the petitioner, Uintah USA Inc.
Your Honor, Elizabeth Harris on behalf of the Division of Oil, Gas, and Mining.
Thank you. I assume that you have some witnesses, Mr. McDonald?
I do, Mr. Chairman, and thanks to the board for allowing our witnesses to appear virtually from Houston. With me today are Mr. Jordan Lear, who is the senior land negotiator. Jordan, would you please wave on the monitor so that they can see who you are? Thank you. And Mr. Brian Power, who is the senior reservoir engineer for Ovintiv. And I would ask that they be sworn in at this time.
Please proceed, Michelle.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
They may have to increase their volume.
Yeah, guys, you may have to speak a little bit louder or get closer to the microphone.
I do.
I do.
Thank you. Mr. Chairman, the resumes of both witnesses were submitted collectively as Exhibit A. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Lear has already been recognized by the board as an expert in petroleum land management in cause number 472-01 last June. Presuming the division has no objection, I ask that the board again recognize him as an expert in that field for purposes of this cause.
Division has no objection. Thank you.
Board members?
All right, thank you,
Go.
Mr. Chairman. Mr. Power is testifying in front of the board for the first time today, and I will qualifying him as an expert in petroleum engineering for purposes of this cause at the commencement of his testimony. Also, Mr. Chairman, in conformance with previous practice, I ask that it be acceptable for me to move for admission of our exhibits at the end of my presentation as a whole.
That's preferable. Thank you.
Members of the board, this cause involves compulsory pooling. Oh,
One thing.
okay.
Mr. Moon has something he needs to disclose.
So I need to disclose that my family has an interest in this well, in this spacing unit. And so needed to disclose that.
Now, I think unless there's some objections from your client or from the division, what we would do is allow Mr. Moon to participate in the discussion, but not vote on the matter.
No objection from our client, Your Honor. Mr. Moon is not, and his family members are not being compulsory pooled here, so we don't see any issue with that.
No objection. Thank you.
Okay, thank you. No problem with that, Mr. Moon. Okay, then I appreciate it. Go ahead with your presentation.
Thank you, Mr. Chairman. Again, members of the board, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 11 and 12 of Township 4 South, Range 4 West, USM, and Duchesne County. The drilling unit was established by the board order entered on August 20th, 2021, in cause number 130-07. A true and correct copy of the 130-07 order was submitted as Exhibit B in this matter. In accordance with the 130-07 order and an APD approved by the division, Ovintiv drilled the Wolf 1-12, 4-4-12-11-7H well is a long lateral horizontal well within the north half of both sections, completing it as an oil well with first production from the Uintah Butte member of the Space Formation on August 8th, 2022. As outlined in the request, all of the oil and gas in these two sections is owned in fee or privately owned. Ovintiv is the majority lessee working interest owner and the operator of the drilling unit. Other lessees include Finley Production Company LP, WEM Uintah LLC, WEM Uintah 2 LLC, and Forex Resources LLC, all of which have executed joint operating agreements and a pooling declaration with Ovintiv, and their elections as to the well are governed by the respective JOA private contractual terms. As a consequence, at the time the request was filed, approximately 98.4% of the drilling unit was voluntarily pooled. As originally alleged in the request, BHCH Mineral Limited, Hardy Mineral and Royalties Limited, Gallagher Headquarters Ranch Development Limited, Travis Company JV Limited, DT Royalty Partners LLC, and Fredericksburg's Royalty Limited were all unleased owners who were provided the requisite opportunity to lease or participate in the well, but never timely responded. Ovintiv therefore originally sought to compulsory pool their interests. However, since the filing of the request, those parties have leased to Ovintiv retroactive to the date of first production, and consequently, there is no longer a need to compulsory pool their interests. As also alleged in the request, Border Resources, Inc., a Colorado corporation, is the record lessee of a lease from Weaver 4 Investments. Border was sent and received the requisite notice of opportunity to participate in the well, but did not timely respond. Absent Border's pooling, the interest of Weaver 4, its lessor, also is not pooled. Consequently, Ovintiv seeks the compulsory pooling of both interests. Since the filing of the request, Ovintiv discovered that Border voluntarily dissolved on January 3rd, 2022, after the notice of opportunity to participate was sent and with confirmed receipt on January 4th, 2022. Service of the request was attempted at Border's business address at which the notice was sent and received, and upon David Conjallo, its registered agent, at his personal address disclosed by the records of the Colorado Secretary of State, but were returned as undeliverable. Service upon Mr. Conjallo, also the president and a shareholder, at his current address in Minnesota, as disclosed by the White Pages website, has been attempted by Federal Express, but requires a signature and has not yet been picked up by him. Ovintiv therefore seeks to additionally declare Border Resources, Inc. as a non-consenting owner. I'll be happy to address that further if the board has questions. As further alleged in the request, Intermountain Resources, Inc. was a record oil and gas owner, but it too became defunct. A deed executed by a purported member of the board of directors and its purported vice president assigned 70% of the company's interest to the Utah State Treasurer State of Utah Unclaimed Property Fund. However, Ovintiv's title counsel has questioned the validity of that deed. In an abundance of caution, the state treasurer in such capacity was sent the requisite notice of opportunity to lease or participate, but never timely responded. In addition, pursuant to the board's order entered on July 18th, 2022, a notice of opportunity to participate relating to the Wolf Well was, as required under Utah Administrative Code R 649-2-9A, to all unknown shareholders claiming by, through, or under International Resources, was published in the Uintah Basin Standard. Again, that notice was published to the unknown shareholders claiming by, through, or under International Resources in the Uintah Basin Standard for 2 consecutive weeks, but no party has responded to that notice or otherwise tendered his or her share of cost for the well. Consequently, Ovintiv seeks the compulsory pooling of all such successors of Intermountain Resources not already leased and to declare them as non-consenting owners. Mary Ellen Slemaker-Benian, Tracy Lee Markham Sherrill, the trustees of the Robert S. Howell and Margio S. Howell Family Trusts, Tracy Brown and Kent Dukes are also unleased owners who were provided the requisite notice of opportunity to lease or participate, but never timely responded. Consequently, Ovintiv seeks to compulsory pool their interests and declare them as non-consenting owners as well. Finally, some of the leases were granted by parties claiming by, through, or under estates of certain deceased parties for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there is the possibility of some unknown party claiming by, through, under the estates who is unleased and not pooled. Again, pursuant to the same July 2022 order from the board, notice to such unknowns were published in the Uintah Basin Standard. No party has responded to that notice or otherwise tendered their costs for the well. Ovintiv therefore seeks to declare any of these unknown parties to be compulsory pooled and also declared as non-consenting owners. The proof of publication to these unknowns or unlocatables was submitted as Exhibit T in this matter. As none of the parties I've addressed filed a timely response to the request, pursuant to Utah Administrative Code Rules R 641-104-150 and R 641-108-400, we move to enter an order of default against them. As to the non-consenting parties, Ovintiv seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement materially the same as signed by the other working interest owners in the drilling unit, in which terms have previously been deemed just and reasonable by the board in other compulsory pooling hearings. During the recoupment period, The unleased non-consenting owners will be entitled to 18.475236% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of spud of the Wolf Well in accordance with the regulations. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R649-2-8A and R649-2-9A. A copy of the request was mailed certified mail or delivered by FedEx to the known parties sought to be compulsory pooled, and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records. In addition to the published notice of opportunity to participate to the unknowns previously mentioned, notice of the filing of the request of this hearing was also duly published in the Uintah Basin Standard and Vernal Express on August 3rd, the Deseret News on August 5th, and in the Salt Lake Tribune on August 7th. The division filed a response on August 10th, 2022, not objecting to the request, but simply pointing out the legal precedent and applicable regulations concerning how the risk compensation award requested should be determined. No other objections or responses to the request were timely filed. With that, I'll commence my examination of Mr. Lear. Mr. Lear, would you please state your name and business address for the record?
My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with Ovintiv?
I'm the senior land negotiator working the Uintah Basin with responsibilities for this drilling unit.
For the record, would you please state Ovintiv's bonding and corporate status?
Ovintiv USA Incorporated is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It's duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Ovintiv Production Incorporated.
All right, Mr. Lear, I'm going to show you what have been marked as Exhibits C and D for purposes of this hearing. Do you see them on the PowerPoint presentation?
I do.
Were they prepared by you or by Ovintiv personnel with your review and input?
They were.
Turning your attention to what has been marked as Exhibit C, would you please explain to the board what this shows?
Exhibit C is a regional locator plat, and it's showing the drilling unit, which is located just south of US 40, between Duchesne City to the west and the Bridgeland community to the east.
Now turning to Exhibit D, please explain what this exhibit shows and its significance.
This is the mineral tract plat showing the general location of the Wolf Well within sections 11 and 12. It's also showing that the surface hole location is outside of the drilling unit to the north in section 1. Pursuant to the order Mr. McDonald referenced earlier, 30-07, an APD approved by the division. The Wolf Well was spud on December 28th, 2021 and completed as a producing oil well with productive intervals within the Uintah Butte member of the Space Lower Green River Wasatch Formation. And the date of first production of the well was April 8th, 2021. Another thing to mention is, although it's not shown on this plat, there is an existing short lateral horizontal known as the Deming 1-11-4-4 WH well, which is located entirely in section 11 and produces from the Wasatch Formation. The well has not reached 100% payout, but the only unleased owner previously carried by Ovintiv has since leased to Ovintiv, including the interest in the Deming well. Consequently, there are no pending recoupments. Further, pursuant to Order 130-07, production allocation from that well converted from a sectional basis to the 1280 acre DSU basis as of May 1st, 2022. And as we described, this is the mineral tract plat. So it's showing 3 mineral tracts that comprise this DSU, being the north half of section 11, which is designated as tract 1, the south half of section 11, which is designated as Track 2, and all of Section 12 is designated as Track 3. All of the interests that are sought to be compulsory pooled are in Track 3. Ovintiv is also the majority lessee / working interest owner in the DSU and is the operator of the Wolf Well. And as Mr. McDonald referenced, the additional lessees / working interest owners in the DSU are Finley Production Company, LP, Uintah LLC, Uintah 2 LLC, and Forex Resources LLC, all of whom have signed JOAs with Ovintiv, the items of which, or the terms of which, contractually govern well elections, including elections made on the Wolf Well. And all of these parties have recorded a pooling declaration as amended, pooling their interest pursuant to the authorization contained in the various pooling clauses of the leases.
Okay, now I'm going to turn your attention to what have been marked as exhibits E through S. There's no PowerPoint for this because it's a lot of paperwork. Are these official business records of Ovintiv that you're aware of?
Yes, they are.
Okay, would you please explain what they represent?
These are the various notices of opportunity to lease and or participate sent for the Wolf Well, along with proofs of delivery, JOAs, and exhibits R and S were attached to each.
I'd like to point out to the board that each of these notices with the referenced attachments reflect compliance with the regulatory requirements under R649-3-1 and R649-2-8A. Starting with Exhibit E, would you please explain to the board what it shows and who the parties involved there?
So this is the notice that was delivered to Border Resources Incorporated. Border is a lessee under a lease from Weaver 4 Investments covering an undivided 0.326667% interest in Track 3. The proof of delivery shows that the confirmed receipt was on January 4th, 2022, and there's been no response received. And although the lease allows the lessee to pool the lessor's interest, since Border has failed to pool the lease, Weaver 4's interest must also be compulsory pooled at this time. However, it is contractually entitled to the 3/16 royalty under its lease.
So in effect, that Weaver Ford as a royalty owner will not be adversely affected by being compulsory pooled. It's simply a matter of the technicality of pooling the lessor's interests as well. Is that correct?
That's correct.
All right, turning your attention now to exhibits F through H. Would you please identify those parties and any significance to those notices?
Again, these are the notices served to each of those parties. Exhibit F is the notice served to Mary Ellen Slimmaker Benign, who is the owner of an undivided unleased interest of 0.21449% interest in Track 3. Similarly, Exhibit G is the notice served to Tracy Lee Markham Sherrill, who is an unleased owner owning an undivided 0.012873% interest in Track 3. And finally, Exhibit H is the notice served to Robert S. Howell and Margio S. Howell as trustees of the Robert S. Howell and Margio S. Howell Family Trust dated April 5th, 2011. And they are the owners of an unleased undivided interest of 0.051491% interest in Track 3. As to all three, no responses were received.
Okay, now turning your attention to exhibits I through N, please explain who those parties are and what the status is with respect to those notices.
So those were the notices served to BHCH Mineral Limited, Hardy Mineral and Royalties Limited, Gallagher Headquarters Ranch Development Limited, Travis Company Joint Venture Limited, DT Royalty Partners LLC, and Fredericksburg Royalty Limited, collectively owning a 0.468601% interest in Track 3. However, since the submittal of the RAA and these notices, all these parties have now leased to Ovintiv retroactive to the effective date of first production from the Wolf well, and therefore no longer need to be compulsory pooled as Ovintiv has now pooled them.
As a consequence, Mr. Chairman, we will not be admitting or asking for admission of exhibits I through N into evidence in this matter. Just wanted to flag that for you. Okay, Mr. Lair, now turning your attention to exhibits O through Q, would you similarly please explain the parties that they were sent to and the significance and their status?
Sure. Exhibit O is the notice sent to Tracy Brown, who is the apparent owner of an unleased undivided interest of 0.001361% in Track 3, and as a claimed successor of Mary A. Eves, deceased. Exhibit P is the notice served to Kent Dukes as the apparent owner of an unleased and undivided interest of 0.004291% interest in Track 3, as a claimed successor of Harley Bruce Markham Sr., Ruth McCormick Markham, Harley Bruce Markham Jr., and Lillian Mary Mole Markham, all deceased. Finally, Exhibit Q is the notice to Intermountain Resources, who owned of record an undivided 3.089472% interest in Track 3. In 2017, Jane N. Sheffield and Gordon A. Nebeker, as member of the board of directors and vice president, respectively, of the company, a dissolved Utah corporation, purported to assign their interest to the Utah State Treasurer, State of Utah Unclaimed Property Fund. 70% of that interest was quitclaimed to the state treasurer. 10% was conveyed to Jane N. Sheffield, and 10% to Dilworth A. Nebeker, and finally a remaining 10% to Gordon A. Nebeker via that quitclaim deed. Ovintiv's title examiner has questioned the validity of the deed, especially as to the unclaimed property fund. The interest of the other grantees is leased or now owned by Uintah 2 LLC. And Exhibit Q is the notice sent to the unclaimed property fund pursuant to the deed.
All right, would you explain also, you said your title examiner questioned the validity of the deed. What contacts did you make to try and determine who other shareholders of Intermountain Resources may have been?
So as referenced, WIM had leased the two named parties there, as far as Jane N. Sheffield and Gordon A. Nebeker. And so I reached out to WIM, specifically Brad Gunnell, to discuss what they were able to ascertain in that leasing process. And essentially, they were not able to track down any further the 70% of the unknown shareholders that are referenced in that deed. The deed was prepared by Gail McKitchney on behalf of Dilworth A. Nebeker, who was his client. I spoke to Mr. McKitchney in July of this year regarding the deed and everything that led up to it. And he was unable at the time of preparing the deed to ascertain from his clients or any of the parties that were still living and registered principals of the corporation prior to dissolution, the identities of any further shareholders.
Okay, now with respect to the parties to whom these notices reflected by exhibits O, P, and Q, did any of them ever timely respond to the notices?
No, sir. No responses were received.
All right. Mr. Chairman, we did not submit either the corporate dissolution paper that we found from the Colorado Secretary of State regarding the Board of Resources, and we did not submit the deed that Mr. Lair just testified to, but we would be willing to supplement the record if the board would like to see those documents. Just let me know your preference on that.
We will. we'll probably have to discuss that
Okay.
and get back to you.
All right. Thank you. All right. Now, Mr. Lair, turning your attention to what has been marked as Exhibit R. Again, that you had mentioned that this is an official business record. Please explain what this document represents and whether or not it was part of the notice that was sent out to the parties you just testified about.
It was included in the notice pursuant to all the exhibits we just went over, as well as all the other notices sent, and it's a survey plat of the Wolf Well.
All right. And similarly, turning your attention now to Exhibit S. This is a 2-page exhibit. I'm going to focus on page 2 here. But again, please explain what this is and if it was included as part of the notice packages.
It's the AFE sent with each notice. As Mr. Power will testify, the AFE was a fairly close estimate of the actual costs incurred in the drilling of the Wolf Well.
And again, these were sent because of the regulatory requirements under the notice. Is that correct?
That's correct.
All right. In the request, we mentioned that there were several deceased parties that still own interest of record. Would you please identify who those parties are and what their status was?
Sure. As you mentioned, Mr. McDonald, there's several lessors that claim title in these lands through one or more of the estates of the following deceased record mineral interest owners, being Frank L. Maxwell Jr., Mary A. Eves, Jane N. Sheffield, Nancy Eves Nicora, C. Ed Philandro, Jeffrey J. Noble, Ruth McCormick Markham, Harley Bruce Markham Sr., William H. Markham, Harley Bruce Markham Jr., Leslie J. Beatty Jr., Lillian Mary Moley Markham, and Verna M. Larson. And as to those parties, either no Utah probate of the estates have been initiated, or if filed, they are incomplete in that there has been no proper distribution made to the heirs or devisees. Currently, although based on affidavits of heirship and other inquiries and research done by Oveniv's lease broker, Oveniv believes it or other voluntarily pooled working interest owners have leased all of the successors. Without an order from the Utah court confirming their succession, the possibility still exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore Oveniv seeks to compulsory pool their interests and declare them non-consenting owners. And referring to Exhibit T, there were no responses ever received to the published notice.
And again, that's the order of the board allowing the publication to those unlocatables. All right, Mr. Lair, I'm now going to ask you to turn to Exhibit U, which was also Exhibit 1 to the request. I've only have certain highlighted portions of that because it's a very long document. Would you please, was this document prepared by you?
Yes, it was.
All right, would you please explain what it is and the significant portions of it?
This is the JOA that was included in the notices. It's a form utilized and is standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontals. It's materially the same form JOA sent with all of the mailed notices just outlined. The terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including JOAs signed by other voluntarily pooled working interest owners in this DSU. Oveniv has prepared identical terms for other drilling units. It has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uintah Wax, EP Energy, and other major Uintah Basin operators.
All right, turning your attention to the PowerPoint, I believe this is page 7 of the main portion of the joint operating agreement. Do you want to highlight or outline what's highlighted here?
Sure, that is the non-consent penalty, and it's reflected as 150% and 300%. It's provided It's the same contained as in the JOA signed by Finley et al.
Pertaining to this drilling unit, is that correct?
That's correct.
Okay, now turning your attention to Exhibit C of the joint operating agreement. Please explain what that document is and its significance.
So that's the COPUS, which is the accounting procedure. Again, this is a standard industry form, almost universally utilized, and is similar to other JOAs in the Uintah Basin.
Okay, turning your attention to exhibit or page C3 of that Exhibit C COPUS. It's on the PowerPoint right now. Would you please identify the highlighted portion there?
Sure. That's part of Article 3B, which sets the interest rate at the prime rate that's published in the Wall Street Journal, plus 3% being fair compensation and to encourage timely payment of chargeable costs and expenses from the non-operators.
All right, and then turning your attention to page 9 of that same COPUS, and would you please explain the highlighted portion here?
Sure, that's the overhead charges for both a drilling well and a producing well under the accounting procedure.
And those are current 2022 rates?
Correct.
Okay. Okay, Mr. Lair, in your expert opinion then, are the terms and conditions of the proposed joint operating agreement fair and reasonable and consistent with those accepted by the other working interest owners in this drilling unit and with those commonly accepted by industry and in particular the Uintah Basin with respect to horizontal well operations?
Yes, they are.
All right, I'd like to point out to the board that Exhibit A to the joint operating agreement that was submitted would have to be modified to reflect the Uintah's increased interest due to the leases that it obtained after the filing of that exhibit. All right. Turning to the average weighted fee landowner's royalty, Utah Code annotated section 40-6-6.56 and 8 provide a compulsory pooled unleased owner is entitled to payment of the average weighted fee royalty landowner's royalty during the payout period determined as of the date of spud of the well. Mr. Lair, I'm now going to show you what has been marked as Exhibit V. Was this prepared by you?
It was.
All right. Would you please explain what this shows? I'm going to turn to page 3, but explain what this Exhibit V represents.
So it's reflective of the calculation of the average weighted fee landowner's royalty for sections 11 and 12, comprising the drilling unit as of the date of spud of the Wolf well. And obviously the sum, the actual calculated average weighted fee royalty is 18.475236%.
All right. Otherwise, would you confirm all of the other land-related allegations contained in the request?
Yes.
All right. Now I'm going to ask you to refer to the certificate and supplemental certificates of mailing. Do you have those documents in front of you?
I do.
Those were pleadings that were prepared by my office and are on file in this matter. Do you recognize the people that are shown on those certificates?
I do.
And who are they?
They are all of the production interest owners within sections 11 and 12. And the addresses were derived from the title opinion, which was effective October 14th of 2021, which has since been updated by a search of the county records by our broker, Lone Wolf, and also supplemented by Uintah's internal records.
All right. Turning the board's attention to Exhibit Z was supplemented on Monday. These are true and correct copies of the certified mailings or the FedEx statements received by my office confirming receipt of the copy of the request by the parties to be compulsory pooled or is returned as unclaimed or undeliverable or the UPS status on them. With that, that concludes my examination, Mr. Lair.
Thank you, Mr. McDonald. Division, do you have questions of this witness?
I do have a few brief questions. Thank you.
Okay.
Mr. Lair, if we could talk first about the border issue. Have you had a chance to ascertain what the status of that lease that they hold with Weaver 4? What the status of that lease is?
So they are the current lessee of record as far as the Weaver 4 interest. There was a lease taken by Newfield after the effective date of this one, and so effectively their lease is the active one right now. So it's still active as of today.
Did you contact Weaver 4 at all since Border was dissolved?
As Mr. McDonald stated, we were unaware of the dissolution until after the RAA was submitted. So at this time, I have not yet contacted Weaver 4.
Okay. On the treasury deed, perhaps you can tell me if I'm understanding this correctly, to the Utah State Treasury. That deed transferred interest to the Utah State Treasurer as well as Jane Sheffield and Gordon Nebaker. Is that right?
It's correct, except for there's a third party. So it's the state treasurer, it is Jane Sheffield, it is Gordon Nebaker, and then it's, excuse me, 1 second. And then also Dilworth A. Nebaker. So it's effectively the three heirs to W.D. Nebaker, who was the president of the corporation prior to dissolution.
Okay, thank you for clarifying that. And to the best of your knowledge, it sounds like they have then leased their interest to WEM. Is that what you testified?
Yes, ma'am, that's correct.
So at least, and perhaps I'm going to ask you to speculate here, but at least WEM appears to believe that that deed was valid as to those three transfers to those individuals, theoretically.
Yes,
Okay.
ma'am, that's correct.
And the division had an individual named Mark Maxwell contact us, and we directed him in your direction. Were you contacted at all by Mark Maxwell?
Yes, ma'am, I was. Mark Maxwell was representing PJ Maxwell LLC, which was a party that's been leased to Oventive and is in pay on the domain well. And I believe there was just confusion around their receipt of the request and what obligations they had pursuant to that. So I was able to explain that he's a party that's been voluntarily pulled as to the Wolf Well here and will receive payment in accordance with the terms of his existing lease.
Oh, that's perfect. Thank you very much. I have no further questions.
Thank you. Board members?
I just have a quick clarifying question. Did you say the Newfield lease predated to Weaver? Predated or postdated the Border lease?
Post-dated, which created the issue because it's effectively a top lease.
But you still believe the Border lease is the effective date? Do you know that all the rentals have been paid and everything?
There's a paid up lease to my recollection, and it's the active lease credited in our title opinion.
Thank you.
Thank you.
Mr. Church?
Mr. Lair, with all the additional interest you have picked up now, what is the total interest that Oventive has committed to the unit? Or to the well, excuse me.
So the amount of working, sorry.
Well, yeah, earlier, Mr. McDonald said there was a 98.4%, so I assume then that's been increased.
Yes, sir. I don't have the ownership in front of me. I can speak to the fact that Oventive has on its own just over 62% working interest. And between the other working interest parties, we've got the lion's share, which should approximate that 98.4, but I don't want to misspeak as to the total there.
Mr. Church, if I can help out on the math,
Please.
Mr. Lair testified that the collective interest that they acquired on those subsequent leases was 0.468 approximately. And since that covers section 12, it would be approximately half of that.
Okay.
So it'd be an additional 2.23%, if my math's right.
Thank you.
Board members, any other questions? I have one. Wanted to get a little bit more information on the 300% penalty. Can you explain that again as to how you arrived at that 300%?
We'll talk to the risks and Mr. Powers' testimony associated with the
Okay.
well, but from a land perspective, this is kind of the standard risk penalty that we've agreed to with other parties within the basin. And so it's pretty uniform in that sense.
Okay. If we have further questions, we will ask the next witness. Thank you.
Thank you.
No other questions from the board, so we'll turn it back over to you, Mr. McDonald.
Thank you, Mr. Chairman. I'll commence my examination, Mr. Powers. Mr. Powers, would you please state your name and business address for the record?
Sure. My name is Brian Power, and my address is 4 Waterway Square, Suite 100, The Woodlands, Texas, 77380.
What's your current position with Ovintiv?
I'm a senior reservoir engineer, and I work this drilling unit, amongst others.
All right. Since this is your first time testifying in front of the board, would you please provide a brief summary of your education, work experience, especially in the Rockies, and any horizontal well development, any certifications you may have, and any previous recognitions as an expert before other oil and gas commissions?
Sure. I've got a Bachelor of Science in Chemical Engineering from Texas A&M. I'll complete my MBA from Rice University in December. I've got about 20 years of oil and gas experience, 12 of which are in the reservoir engineering side. I've worked for Southwestern Energy, Oasis, Petroleum, Anadarko Petroleum, Occidental Petroleum, before joining Ovintiv in 2020. I've worked the Rockies for approximately 8 years, primarily with Ovintiv and Oasis Petroleum. And I have testified as an expert witness before for the NDIC.
All right, Mr. Chairman, with that summary as well as his resume, I would move that the board recognize Mr. Power as an expert in petroleum engineering for purposes of this cause.
Division, any objection?
No objection. Thank you.
Board members? And then he is so recognized as an expert witness.
Thank you, Mr. Chairman. Mr. Power, I'm going to turn your attention now to what has been marked as Exhibit W. Was this prepared by you or Ovintiv personnel with your review and input?
Yes, it was.
All right, would you please explain what it shows?
Yeah, so this shows the actual invoice drilling costs and completing costs incurred for the Wolf 7H. The first 4 lines indicate the capital spent on the well. It's approximately $7 million. It's about a 10% difference from the $6.3 million that Mr. Lair testified to in the AFE. The increase in cost is primarily associated with the increase in completion cost, and that was due to inflation that occurred from when the time the AFE was sent in December 2021 until when the well was actually drilled in March of 2022. The price of oil inflated pretty significantly over that time.
All right, and just to clarify for the record, this reflects the actual cost incurred in drilling and operations through to June 30th, 2022. Is that correct?
That is correct. Yep.
All right, is it your expert opinion, therefore, that the costs incurred were fair, reasonable, and necessary, and that the well was deemed economically feasible, as that term is used in the board spacing order to drill?
Yes.
All right, would you please identify for the board what is the estimated plugging and abandonment costs for this well?
Yeah, so $75,000 would be the plug and abandonment charge. that we've determined through Oventive. And that'd be based on 100% working interest ownership.
All right, now turning your attention to what have been marked as exhibits X and Y. These are shown on the PowerPoint. Were these prepared by you or Oventive personnel with your review and input?
Yes.
All right, turning your attention to exhibit X, would you please explain what it shows and its significance to this matter?
Yeah, Exhibit X is a plat of the existing Uintah Butte wells at the time the Wolf well was spud. There's two 10K long laterals that are shown on here, the Beal wells, both drilled in 2018. There's also two shorter wells, the Domine and the Ute Tribal 4WH. All the wells are Oventive operated. And then it also depicts where the Duchesne fault zone is, about 1.5 miles to the south of where the Wolf well exists.
And what is the significance of the lay down versus stand up orientation of these wells?
Yeah, so due to the stress plane from a optimal least principal stress, we decided to drill these wells east-west in order to maximize the completion efficiency out here. You also have the Duchesne fault zone to the south, and so that also created a potential structural and operational hazard, particularly from a drilling fluid loss and potential hydraulic fracturing complexity standpoint.
All right, now turning your attention to exhibit Y, do you want to go through each of these points for the board?
Yes, so with Exhibit Y, there are some pre-spud risks from both a drilling and operational standpoint. So as was mentioned before, due to the principal horizontal stress, the pad was the first laydown execution for 10K wells in the area. There's also the drilling risk of a sidetrack and stuck BHA due to higher clay facies within the target zone. There's the collision risk due to the proximity to the Domine 1-11 4-4WH. And then there's also drilling fluid loss risk due to the Duchesne fault zone. And then when it comes to the actual occurred risk on the well, we did not experience any execution risk.
Is it your expert opinion, therefore, then, for these reasons, there was sufficient risk at the time of spud to justify a 300% risk assessment award in this matter?
Yes, it is.
All right, and do you confirm all of the other engineering allegations contained in the request?
Yes, I do.
All right, that concludes my examination of Mr. Power.
Thank you, Mr. McDonald. Division,
No questions, thank you.
board members, do you have questions of this witness? Thank you for going over Exhibit Y and why the 300% penalty is, in your opinion, reasonable. That answered my question.
Mr. Chairman, that concludes our presentation in chief. At this time, I would move for admissions of exhibits A through H, O through Y, and Z as supplemented.
Let me read that back to you. A through H, but I through N or M?
N.
N as in Nancy. Okay.
Right, they are not being admitted.
And then M through Q is they're not included. I'm sorry. Could you list those again?
Yes.
My list is a little bit.
It's A through H.
Okay.
Okay. O through Y.
Okay.
And Z as supplemented.
Great. So admitted.
I'd like to reserve a little bit of time if the board has additional questions just to address these issues concerning border and the deed and provide a little more legal argument about those.
Okay. Well, we will turn the time over to the division if they have a presentation.
The division doesn't have any presentation. Our only concern was the justification for the 300% penalty. I appreciate Mr. McDonald putting that evidence on the record. We do have concerns about some of the title issues, but we can wait on that until closing argument.
Okay. Board members, do you have any questions before closing arguments? Mr. Moon?
Yeah, just a question on that other horizontal well that you came close to that was going the opposite direction, the Domingue. Not sure how to say that well name. How close were you to that? You said that it's only producing from the Wasatch. Just had a question about that. Why it's only a Wasatch? Oh, it's horizontal well, so it would be a Wasatch well. How close were you to that? Did you have to adjust your fracking or anything like that related to that well? Any interference? Just wanted to know about that.
Yeah, from a proximity standpoint, I don't know the closest perf from that standpoint, but just visually speaking, the wells almost lower the top of where the surface hole is. I'm not sure what the actual nearest point between the two wells are. And then from sorry, what was the other part of your question there?
Just the distance and any interference happened, during as you began producing.
Yeah, I'm not sure if there was any interference there. There was nothing done from a completion standpoint to skip stages or anything like that. I don't believe the Domain took a big frac hit on during the completion of the Wolf, but we can follow up on that.
Thank you.
Mr. Moon, if I can also clarify, the Domingue well was a Wasatch well, and this well, the Wolf well, was a Uintah Butte.
There are no further questions. Division, do you have anything else? Okay.
Other than before closing argument, would it be possible to take a brief recess just to consult with my client?
Absolutely.
Thank you.
We'll go off the record until they're done. me a heads up.
You're live.
Michelle, we'll go back on the record. Division, we'll turn the time over to you. If you have anything you need to discuss after your consultation.
No, I just have closing argument. Did you want me to go first or?
No, we'll let
Okay.
Mr. McDonald go first.
Thank you.
I just thought maybe after your conference you had something to add, but
I think we have an understanding, Mr. Chairman, so
excellent.
we'll go ahead and go through this, okay?
Okay.
It seems like the only hang-up here is the issue of the border resources situation, which I'll explain first, and then the issue of the state treasurer and Intermountain Resources, okay? Now, border resources is the last lessee of record of a valid lease, as Mr. Lair testified. Under its lease, it pays a 3/16 royalty to the lessor, who is Weaver 4 Investments. As in a typical fee lease, it contains a pooling clause that grants the lessee the unilateral right to pool the lease with other leases in accordance with state spacing or voluntary or whatever, the situation is. The reason we named Weaver 4 was because Border has not voluntarily pooled its interest. The lessor's interest has to be pooled as well. But there is no adverse impact upon Weaver 4. It will get its 3/16 royalty during the recoupment period, okay? Once the recoupment happens, then it's Border Resources' responsibility to clear up its title and distribute to its shareholders so that the lease remains valid and goes forward from there. But during the recoupment period in this situation, they get the 3/16 royalty. She's not adversely affected by that. It's simply compulsory pooling her interest because her lessor or her lessee failed to do that. Okay, so that's the border situation. They did receive it while it was a valid corporation. We have proof of the receipt, and we've, like I said, they have to take care of their own affairs to distribute that. Okay, now Intermountain Resources. As Mr. Lair testified, the last owner of record of this undivided mineral interest in Track 3 is Intermountain Resources, Inc. It has been identified as a defunct Utah corporation. The deed was supposedly from one of its board of directors and a vice president. It was made to 3 parties who are identified supposedly as shareholders, and then 70% to the state treasurer. I think we're 3 council, at least here, are in agreement that that's probably invalid to the state treasurer, in that when you have unclaimed property, the statute and particularly the regulation involving unclaimed property states that the state treasurer is to receive revenue, not real property, revenue. Under state statute, when a corporation dissolves, the shareholders are the owners of the property. And the normal process is you appoint a liquidating agent. The liquidating agent executes a deed to those shareholders. How Mr. McKechnie came up with the process that he did, I'm assuming he would look through the books, he talked to the shareholders, and he was unable to determine at least 70% of the shareholders. Now, the question is the validity of that deed as to that 70%. Okay, it may be to the other parties too, but that's a separate issue. In this situation, what Uintah did was notify the state treasurer just because the deed's out there. But more importantly, they published notice to unlocatables in the same manner you would any unlocatables who are heirs or devisees, which is the way that the regulations provide for this situation. The notice went to anybody claiming by, through, or under Intermountain Resources, Inc. It was published. There's been no response. And therefore, we believe that they should be deemed a non-consenting owner just as you would if you had an unlocatable heir. And the same process was utilized. So that's why we're explaining what we've done here. It is not Uintah's job as an operator to go quiet title to somebody that they don't have any interest in. They're merely the operator of the well trying to get pooled and taking care of the revenue. What Uintah will do is, if that deed is invalid or it's questionable, they will suspend the revenue attributable to that 70% for the period of time authorized in accordance with the revenue or with the suspense statutes that you have. And after the period of time, it's 3 years, then turn over any revenue over to the state treasurer as revenue, not as a real property interest. and then it will stay with the state treasurer until somebody takes an effort to clear up title and make a claim to it. Now, whether that's Mr. Nebeker or the Nebeker heirs, or whether that's WEM, whether it's some other shareholder that's out there, that's their responsibility. But as far as compliance with declaring a party as non-consent and compulsory pooling, Ovintiv has done everything it can do within its power in accordance with the regulations to have that happen. So that's why we would ask that the request as submitted be approved. Thank you.
Thank you. Division?
Thank you. I think for the most part, Mr. McDonald has done an excellent job of supporting his request for agency action, and the division has no objection to the vast majority of it. The issue with the state treasurer deed is problematic. It's a problem that we've got half of the deed that is being deemed valid that has transferred 30% of an interest to the Nebekers and the woman that I cannot remember her name, unfortunately. Sheffield, thank you. And then the 70% that should or shouldn't go to the state treasurer. The division's a little concerned about whether it should be the 70% of that interest that should be held in suspense, or whether it should be 100% of that interest that should be held in suspense. Until that deed, there's a quiet title action and title is adjudicated, which unfortunately doesn't happen here. Someone else has to do it elsewhere. It's very possible that this could be cleared up. I unfortunately came into this matter last minute since Mr. Gruelle was ill. I would request that there be some post-hearing briefing on this issue about what the appropriate amount that should be held in suspense is. And at that point, perhaps all of the concerns can be resolved and the division would have no objection. But that is, of course, up to the board, whether that would be helpful to you or not. And other than that, I think we are okay with the order being entered as requested. Thank you.
Thank you. Board members, do you have questions for either party? Yes, go ahead. Yep, we're going to have this microphone.
Yes, I was just curious, what percentage of the well is actually related to Intermountain Resources, Inc.?
If you give me a second here, Mr. Moon, I'll be happy to answer that question for you. Intermountain is, as shown in the request, and as I believe Mr. Lair testified, owns 3.089472% in track 3. So in the drilling unit would be approximately half of that would be the corporation. So you're talking about maybe 1.5%. Okay. And so it'd be 70% of that 1.5%.
Question I have, I'm sorry, go ahead, Mr. Moon.
What has the Mr. Nebeker and Ms. Sheffield said about this? What do they believe? Do they agree with what the deed did? What have we talked? What have they said?
Mr. Lear, if you can correct me if I'm wrong here, but I think the situation was one of the Nebekers went to Mr. McKechnie to resolve this, to get title into them. And then of those three parties, one of them title into them. And then of those three parties, one of them, Mr. Dilworth Nebeker, actually conveyed his mineral interest to WEM Uintah. And then the other two parties executed leases to them. So that's all I can tell you that we know about it, is the presumption that they thought that the deed that Mr. McKechnie provided gave them the interest that they were entitled to.
But just 10% each. What about the 70%? What do they believe should have happened there? Or
it's only speculation. I can't even begin to guess that. But my guess would be, is based on what Mr. McKechnie told everybody, is that they didn't have complete books of who the shareholders were, and that the only confirmation they could make was that the three of them each owned 10%. And so that's why he did what he did, and instead of either putting it in, other actions that he could have taken.
Okay. Thank you.
This is just a quick question, Fred, on the border interest. I assume the full 3/16 attributable to the lessees will go to the lessees, and the costs associated with the border lease will be charged against border. They won't receive any proceeds or any part of the weighted royalty or anything.
That's correct. There's no weighted royalty in that situation because it's a leased interest. The weighted royalty only applies when you have an unleased owner. So that Weaver 4 would get their 3/16 under the lease terms payable by the consenting owners during the recoupment period.
And border will bear the costs associated with that.
Well, it's through recoupment. There's no
Right.
revenue stream to border
Right.
during the recoupment period.
Right. Thank you.
I got a question.
Sure, go ahead, Mr. Ward.
Okay, so initial production was in April of 2021, as I recall. 2022? Oh, okay. So you've only got about 5 months of production at this point in time. So do you have any potential for projecting when payout at 300% is going to happen? I mean, how much time do we have to somebody to figure this whole thing out? Is it going to be 10 years? Is it going to be 2 years?
Jordan or Brian, do you guys have any idea or want to speculate on that?
I have not looked into that as far as a 300%. So be cautious to make a comment about that. But maybe Brian.
I mean, it would be longer than 2 years. I mean, with current prices, it's probably less than 10 possibly, but in a normal environment, if you're thinking long term, 10's probably closer to right than 2, I'd say.
Okay, thank you very much.
Any further questions from the board? It's an interesting issue before us, and I think that we'll need to deliberate to have a discussion.
All right, Mr. Hanson, if you could also just keep in mind, if you would like me to supplement the record with that deed and the dissolution information about border, I'd be happy to do that.
Yes, that will be part of our discussion.
Okay.
Thank you. So I think we'll take some time to deliberate. We'll go off the record and come back as soon as we have a decision.
1.
All right, we'll go back on the record. Michelle, are you ready? Great, thank you. Well, the board has deliberated, and there's a few things we want to clear up here before we have a motion. The three issues that you wanted to, or three additional documents that you want to add to the record?
Yes, Mr. Chairman, I don't have them with me, but I will submit them as soon as I get back to my office. I'm going to submit as Exhibit AA, a true and correct copy of the lease from Weaver 4 to Border Resources that we've discussed. That will be obtained from the Uintah County Recorder's website. Exhibit double B will be the statement from the Colorado Secretary of State's office showing the dissolution of Border Resources, Inc. Again, that will be taken off of their official website. And finally, what will be submitted is Exhibit double C will be the deed from the Border Resources, Inc. Board of Director and Vice President of the defunct corporation to the Unclaimed Property Fund and the other three grantees as was testified. Again, that will come from the official website of the Uintah County Recorder. Or excuse me, Duchesne County. This is Duchesne County.
Okay. Okay, thank you. And board members, you have any further discussion before the motion? Mr. Borden.
Yeah, I just wanted to make an observation. I think after deliberation, the board agrees with the appropriateness of the 300% risk compensation award in this case. And that is based on the technical presentation of the risks associated with drilling and production for this specific well. We thank you for that, and we just encourage anyone presenting before us regarding risk compensation to give as much technical detail to justify it. So thanks.
Thank you. I think at this point, we're ready to hear a motion.
Yeah. Mr. Chairman, I'd like to make a motion to approve the request for action, agency action, but place in suspense the 70% deeded to the state of Utah of Intermountain Resources Incorporated interest until the title is perfected.
Is there a second on this motion?
I'll second the motion.
Thank you. Discussion? Hearing none, I guess we will vote on it. All those in favor say aye.
Aye.
Any opposed? Pardon me? Yes, we do have one member who is abstained, Mr. Moon. And but it sounds like the motion is passed. Mr. McDonald, could you prepare the order?
Certainly. Thank you for your time.
Thank you. Thank you, Division. At this time, before we adjourn the hearing, I understand that it may be necessary to go into a closed meeting to discuss strategy pertaining to pending or reasonably imminent litigation. Is anyone on the board willing to make a motion to go into closed meeting?
I make a motion, Mr. Chair.
Is there a second?
Second.
Julianne, could you conduct a roll call for this matter? Roll call vote.
Mr. Richard K. Borden, how do you vote?
Aye.
Mr. Stephen B. Church, how do you vote?
Aye.
Ms. Levon J. Garrison, how do you vote?
Aye.
Mr. Chris D. Hansen, how do you vote?
Aye.
Mr. Gordon L. Moon, how do you vote? Ms. Selma Sierra, how do you vote?
Aye.
Mr. Alan J. Walker, how do you vote?
Aye.
Sounds like the vote's been unanimous. And we will go into a closed meeting. We'll, at the conclusion of our closed meeting, the board will reconvene to adjourn. So we'll be back. I suspect that we'll be back in about 45 minutes. So what would that be, 1:30 about? We'll come back around 1:30 to adjourn. We'll go off the record. Thank you.
You're live, Mr. Chair.
Okay. We've concluded our closed meeting. And I guess we will entertain a motion to adjourn.
I move that we adjourn.
So moved. All in favor?
Aye.
We're adjourned. Thank you for waiting on us.